Chapter 5. Searching for Name Conflicts. Over the course of the first few chapters, you've heard me mention several times the value and importance of searching for a name before committing to it. Now, Chapter 5, we're going to dig deeper into searching. When developing a new brand name, the second major step after brainstorming name ideas and developing a solid list of possibilities is to do some preliminary searching to see if there are any obvious conflicts in use that could present an infringement or a registration issue. A preliminary search may easily turn up some results of competitors already using a similar name for a similar product or service. And it may even inform you if there's a pending application or registration that could block your application. Generally speaking, you can probably eliminate some names based on your own preliminary search. Of course, it is also recommended that after you conduct your own initial search and weed some out in the process, that you consult an attorney for a more comprehensive clearance search and analysis. Without performing a full clearance search, it is impossible to know for certain whether another company is already using the same name or a confusingly similar one in the marketplace. And you can never be 100% certain, but what you're looking to do here is to minimize the risks as much as you can possibly control. Only an attorney can really help assess whether another name or use is confusingly similar or presents a trademark protection problem. Searching for logos presents additional challenges. It's a common misperception that if the U.S. Patent and Trademark Office trademark site is searched via their search engine, the Trademark Electronic Search System, or TESS, T-E-S-S, common misperception that if that is searched and no one else has a conflicting name with the USPTO, that name is safe to use. That is an incorrect perception. Another brand name could still have superior rights based solely on their use of the name. This is called common law rights, even if they never applied to register the trademark at the U.S. Patent and Trademark Office. So a search of the USPTO is valuable, but by itself, it does not provide a full picture of the potential risks surrounding a name. There are a variety of types of trademark searches. Almost always, a comprehensive search and analysis from an experienced trademark attorney is advisable to determine whether a new brand name is available before investing in it, using it, and protecting it. Part of any comprehensive search includes a thorough search of the USPTO records, but also includes domain names, state records, business databases, online search engines, and more. A thorough search must also contemplate alternative spellings and spacings and other variations of the possible name. For example, if searching for free ride, one should also consider free ride with no space, free rides plural, free ride with a Y instead of an E, free ride with a PH instead of an F, ride free, the backwards of the names, free ride with a hyphen, and other variations. Once all of the data from a comprehensive search is obtained, an analysis of the potential conflicts must be undertaken. Such an analysis is not simple and depends on the strength of the relative terms, the amount of overlap, the potential dilution of the marks at issue, variations in goods and services, and more. That's why it's important that an experienced trademark attorney help you conduct and analyze the search. There are some great free sites where you can get started on doing some searching. In the book, I list a couple of them. I'll just briefly here mention Window One, windo1.com, allows you to type a search one time, but perform it in a variety of different search engines at the same time. Amazon, of course, just because of their size. Hoover's is a great business database that's been around for many, many years. CIPO is the Canadian Trademark Office. That might be something worth searching. And you can find the other examples listed in the book. Remember, these tools are a helpful start. Consulting an experienced attorney for more information about a clearance search and a thorough analysis of the search findings is very, very recommended. 6 steps to a branded, protected name. First, brainstorm for brand names. Second, narrow the list to several possibilities that you like. Honing in on one name too early, only to find out that that name is unavailable, is more likely to lead to a really hard, difficult time letting that choice go and making it more challenging to consider alternatives. And therefore, it can lead to a loss of valuable time when you're trying to work on this project. 3, consult with a trademark attorney to see if your preferred names have potential. 4, choose 1 or 2 favorite names, now that you've narrowed the list a little bit, for a thorough trademark search or comprehensive search. It may take a few weeks to clear a name with a comprehensive search, and even longer for the USPTO to review a new application. If possible, you want to give yourself a leeway, a head start of at least 6 months before you're going to be launching the new product or service, so that you can properly select, clear, and file the new trademark application. Number 5, check domain names. Again, not always critical that you have an exactly matching domain name, but you should at least want to know what's out there and make sure that the domain name, if it is taken, isn't being used in a way that competes with how you would use it. 6, if a favored name is available, acquire that domain name and file a trademark application as quickly as possible with the USPTO based on your intent to use the trademark in commerce. The brand strength grid. As you'll see in this visual that we've worked hard to create, a brand has 2 core elements or axes determining how strong it is. One is whether it's a good name, and one is whether it's a registered. Now, what do we mean by a good name? What we mean is if it's a descriptive or a common name, it's going to be vulnerable. And obviously registered, is it registered or is it not? So the best name is registered and creative and unique. That's going to lead to the top right corner where you have a valuable and well-protected brand. The worst case is when you have an unregistered name that is descriptive or common, and then in the bottom left corner, you're going to have minimal rights and ability to exclude others. The 2 intermediate zones are the top left, where you have a creative name, but it's not registered, and what you're left with is a vulnerable asset. And the bottom right quadrant, where you have a descriptive name and you've managed it to register it, but it's still descriptive or common, so you're still going to have limited protection against infringers. Hopefully, your brand fits into that top right quadrant of the brand strength grid. If you need help figuring out where you fit or what steps you might want to take to get into that quadrant, make sure you contact an experienced trademark attorney. You know you can always connect with me at ericpelton.com.